Good morning. It's the appointed time, and we have a quorum. I call the meeting to order. Let's invite the government officials to enter the room. The administration have submitted a paper on their proposed amendments and the points raised by members. The paper is CB bracket 2733/2024 bracket 01. If members have any questions regarding the paper that I just mentioned, you may press the button. Welcome, Undersecretary Mr. Clarence Leung, Director, and government officials for attending this meeting. The government have submitted a list on the list of amendments to be moved during the committee stage amendment. Would the administration walk us through the paper that they submitted yesterday, that is the supplementary information on issues arising from the meeting on the 7th of May? Undersecretary, please. Thank you, Chairman. I will say a few words first. If Chairman and members agree, I will defer to Assistant Director Mr. Lee to walk you through the paper. In the last meeting, the Bills Committee has finished with this clause-by-clause scrutiny. I would like to thank the members once again for their invaluable comments. And in the supplementary information submitted by the administration, it is set out that the government will be moving CSAs. We have taken on board members' views, and after deliberation, we have taken on board a number of comments put by members. So we will be moving committee stage amendments. In the paper submitted on the 28th of May, that's just part of the CSAs. It involves clauses 3, 4, and 8. The yellow marked lines include the criminal offenses. If MCs violates the relevant provisions, all members of the MC will be subject to criminal liability, and members think that is too stringent. That is why we impose the relevant liability on only the accountable MC participants. And the CSA will specify that the accountable person is the person who has assumed responsibility as a participant of the MC at the time when the contravention of the provisions occurred. CSAs will be moved on certain interpretations as well. Members may refer to the list of amendments tabled. We will reply to members' inquiries as soon as possible, and we will be submitting our proposed CSAs very soon. I would like to show my appreciation to the members, the GOJ and HAD staff members. They have been working day and night over the past 2 days for preparing the CSAs in both Chinese and English, and they will be made available in a very short time. I will ask Assistant Director to walk you through the proposed amendments. Thank you. So please refer to the list of amendments and the draft CSAs together. That will be easier to understand. I will walk members through the amendments with the aid of the list. If you may refer to the list, the first item is on the amendments to Section 2, Bracket 1, and Section 2BA. Section 2BA is new section. As mentioned by Undersecretary during his opening remarks, we want to define persons accountable for contravention of the BMO so that we can respond to members' concern. On page 2 of the annex, we define what accountable means. And it means in relation to a contravention of or a failure to comply with an order made under this ordinance. As for accountable or responsible person, you have to refer to Section 2BA. If you refer to page 7 of the annex, it's the new Section 2B. That's the references to person accountable for a contravention. Bracket 1. This section applies where a provision of this ordinance provides that a person who is accountable for a contravention of this ordinance commits an offense. Such a reference will be available in the proposed CSAs. Now we move on to bracket 2. For the purpose of the provision, a person is accountable for the contravention if the following conditions are met. So what are the conditions? A, the contravention occurs because a management committee fails to perform a duty. And bracket B, at the time of the contravention, the person is, as a participant of the management committee, assuming responsibility for taking the actions required for the management committee's performance of the duty, whether expressly or by implication. Bracket 3, under Section 2BA. In this section, a reference to a contravention of this ordinance includes a failure to comply with an order made under this ordinance. This is about Section 40B because the authority can make some orders, and if there is contravention, then the person will be subject to liability. Please pause here. Ms. Doreen Kong, please. Thank you, Chairman. I would like to ask about the proposed new Section 2BA. It says if the person or a member of the management committee fails to perform a duty, then the person will be held accountable. I don't object to this idea of accountable person, but well, as for the duties of secretary and treasurer, I do understand what their duties are, but I think that there are, say, 8 to 10 members of a management committee, but as for their duties legally or administratively, we don't really know that, and they're not set out in the guidelines or in the laws. When we introduce this idea of accountable person, and it seems that only those who don't fulfill their responsibility will be subject to criminal liability. So when I join a management committee as a member, I wouldn't know what my responsibilities are. So how do we clarify who would be accountable or held accountable? Assistant Director. If we refer to bracket 2 of Section 2BA, A, if the management committee fails to perform a duty, then the person accountable will be subject to liability. In the bill, there is often reference to what the management committee should do. As the Undersecretary said in the opening remarks, there were members who said that not all members of the management committee should be held liable for contravention. If all members of the MC need to be held accountable for all kinds of contraventions, then that may not be reasonable because some members of MC may not be aware of what's going on. And there were LegCo members who said that this will discourage owners from participating in the duties of MCs. And at that time, we agreed that we should focus the liability on the persons who should be held accountable. If you refer to Section 2BA, bracket 2, bracket B, it says at the time of the contravention, the person as a participant of the management committee, we have defined it, that include a member, secretary, and treasurer, assuming responsibility for taking the action required for the management committee's performance of the duty. So that's the criteria for us to assess if the person should be held accountable. But then, of course, we'll look at the actual circumstances at the time. The prosecutor will look at all the evidence before they substantiate if someone should be held accountable. We want to protect the members of the MC so that they know that not all members of the MC will be held accountable for any contraventions. Mr. Chan Xiu-hong. Thank you. Section 2BA would be applicable under certain circumstances, including the failure to keep records, including minutes, and the proxies, as well as the procurement documents. We discussed previously that there would be perhaps cases where people would inadvertently be caught by the law because some members may just, or some people may just be a member of the MC without taking any duties. And when a MC procures for service and goods, then the MC may appoint someone to carry out such a procurement. I know that apart from the members who were appointed to procure for the relevant goods and services, there could be other members of the MC who would help out. Then the persons who have been appointed will be held accountable. But then for those who, well, because it says here the law that whether the person is expressly by or by implication responsible, then they will be held accountable. So that may discourage other members from helping those who have been appointed from the procurement. So when we have these reference of expressly or by implication, I'm worried that there could be confusion. What accounts for violation of the laws? And I think that this expressly or by implication is not clear. That may deter people from helping those who are responsible for procurement because they may be caught by the law inadvertently. Thank you.
Mr. Lee, please. Thank you, Chairman. To address Mr. Chen's concerns, on the management committee, different people do different things. Say on a procurement exercise, someone is primarily responsible, and then other MC members take part by helping out. Mr. Chen is right that the extent of help depends on the circumstances of each case. You cannot draw a hard and fast line saying that at a certain level you have helped to a certain extent as to warrant liability. In a procurement, someone may have helped someone post a letter or a document, but that person hasn't taken part in the drafting of that tendering document. So in that case, this person is not involved in the substantive work. So if prosecution is needed, people will look at the evidence. There are also statutory defenses. This person only has to raise an issue, and then the prosecution will have to prove the contrary beyond reasonable doubt. The person being accused can simply say that they don't make the decisions, they have simply, say, posted a letter, and that's all. In that case, the prosecution will be hard-pressed to prove beyond reasonable doubt that this person is accountable. Now, on the point about expressly or by implication, this is a concept commonly involved in common law. Say, on the written record in the minutes that the MC decided to appoint certain people to do certain things, that's a case of expressly assuming responsibility. But in other cases, there may be an oral agreement. That's also another form of express assumption of responsibility. Now, by implication, we're looking at something that happens by habit. In that case, there's no written or oral appointment. But then someone is usually the person tasked with doing certain things, as, say, the secretary or the treasurer. So in that case, MC members, we know that a certain person performs certain tasks. That's an example of doing something by implication. When it comes to prosecution, evidence has to be gathered. Investigators will have to talk to the MC members. The investigators have to gather the documents, talk to the MC members to ascertain whether they agree that certain person does certain thing. Again, it all depends on the circumstances of individual cases. Mr. Lai Tong-kwok. I welcome the draft amendments from the government. We were on the point about expressly or by implication. The focus is on assuming responsibility as a participant. Expressly or by implication, we're talking about the assumption of responsibility. We have to look at the context, the entire course of events. Whether the actions of that person amount to the assumption of responsibility, that's a question of fact. Whether the MC has appointed someone to do something, whether someone does something in the usual course of things, is beside the point. This point is not obvious from the Chinese text, so I looked up the English text. The English text is clear. Of course, the prosecution has the onus of proof. It's for the prosecution to prove something. Say a document needs to be kept for 6 years, but this person has lost it. So who's accountable? Who's responsible for locking up the document? The minutes may not spell this out clearly. but a certain person has the keys. So in that case, you will see a case of assumption by implication. I think the drafting as it stands looks fine to me. Members, please also note that previously all MC members were to be held accountable, but now we're narrowing the scope of accountability. So someone who is tasked to do something is likely to be the participant, but then we will also get to the defense. So this can allay the concerns of the other MC members. Someone is not tasked to do certain things, but then people assume that that person will do certain things. So we want to avoid that kind of situation. Mr. Rincon. Under 2BA, something remains unclear. Say I'm an MC member. I engaged a management company to do certain things. When it comes to collecting proxy forms, that person may not be personally involved. But the new section 2BA is also vague on this. Say I gave an instruction to a property management firm to perform a task. Does that relieve me of my responsibility? Does that mean that I'm all good? Can we have greater clarity here? Since we have section 2BA here, can the Bureau explain this and shed light on this point? Mr. Lee. When we get to 4B, members will see a statutory defense. To return to Ms. Kong's point, say the MC has asked the management firm to do something, such as to keep the minutes. This may be in the contract with the PMC. In that case, the MC member has discharged all due diligence. In that case, when a complaint comes along, we will look at the circumstances. In that case, prosecution may be hard. So there is already protection for the MC member. Mr. Lo Wai Kwok. Chairman, I support the amendment about the accountable persons. At previous meetings, members worried about having too wide a scope in who we hold accountable. Some may argue a wider scope may work better, but that is not the case. I got asked, no one on an MC is willing to keep the documents. What happens then? In that case, that owner's corporation is as good as non-existent. Because previously, keeping documents may attract criminal liability. In that case, people won't want to do that. So now the government proposes the amendments that's being responsive. Now, even for someone without a legal background, we think the phrasing is clear. The contravention arises when the MC fails to perform the functions, and then this person is assuming responsibility for taking the actions, whether expressly or by implication, at the time of the contravention. I think this is clear. In this case, the MC fails to do a certain thing, and the accountable person is acting in the capacity of performing certain functions for the MC. I think the phrasing here is clear enough. But then the phrase responsibility for taking the actions required is also vague. Someone may be holding the keys. That also has to do with taking the actions. So does that go far enough in allaying concerns for OC or MC members, Mr. Lee? We try to clarify things as much as we can in drafting. When it comes to criminal liability, things get serious. We look at the facts of each case in determining whether a certain person is involved in the action. So we take a rigorous approach. First, we decide whether this person is involved and whether this person had the responsibility to perform certain actions. And then, further down the road, there are statutory defenses. This person may be able to raise the point that this person wasn't given the task to do a certain thing. So Section 2BA is about responsibility, and then later we introduce a defense. The defendant can simply raise an issue, and then the prosecution will have to prove the contrary beyond reasonable doubt. So this is belt and braces. That should be enough to allay the concerns of the MC and OC members. LegCo discussions also matter. We talk, we clarify matters to make sure the provisions are potent and avoid causing undue concerns. Our proceedings here also reflect the legislative intent. We're not trying to catch everyone whether they're involved or not. I think the public will accept that we're simply trying to get to the people directly involved. We're close to the conclusion of the scrutiny. We may have just one more extra meeting. The proceedings at LegCo show the healthy interaction between the executive and the legislature. I think we all get Mr. Low or Dr. Low's point. Now I want to let Mr. Andrew Lam speak before we get to Mr. Chen Xiu-hong. Mr. Andrew Lam. We want stiffer criminal penalties. We also want to encourage participation. We want to strike a balance between those two factors. I thank the government for being patiently addressing our concerns. As Mr. Alfred Lee said time and again, we want to clarify where the primary responsibility falls. So, who's a participant? We don't want to catch people who are not involved. If I took part in the voting, of course I'm involved. In building management, there may be malicious attacks. As we tighten the rules, these tightened rules may be used as weapons, and we need to stay alert to that. This bill is complex enough. Going into further granular detail may make the law even harder to follow. Overall, I find the bill acceptable. We just need to explain more clearly where the primary responsibility lies. People working in NGOs have to take out insurance because they anticipate actions, legal actions taken against them. The entire board at an NGO may be sued. So I hope the government can explain these details clearly. Criminal liability aside, hassle for MC members is also a point of concern.
Mr. Lee, we note the members' views and we will step up public education. Mr. Chan Xiu-hong, please. Thank you, Chairman. I agree with what the members just said. By adding this section to BA, our concern will be addressed so that not all members of the MC will be held accountable. Now, the scope of accountability have been narrowed down, and we have clearly defined the responsibility to be held by each and every person. If more than one persons have been appointed to carry out the procurement, and if those people are not familiar with the procurement procedures, and some other members may help them out, and under such circumstances, those people who are helping out may be caught by the law. They may argue that they're just helping the relevant members out in the procurement, and some misguided advice may be given, and as a result, the members responsible may be held accountable. I don't think that we have to detail all these out in the laws. For regular members of the public, they may not have enough legal knowledge before participating in the MC, and they may seek advice from someone else. That's the scenario that we have to take into account. I think that the administration should also roll out Q&As and guidelines, and they should incorporate the scenarios that I just mentioned into those guidelines and online Q&A, so that potential members of MC will be aware of such potential scenarios. I think that the administration can consider this. Thank you. The possible scenarios are numerous. It's impossible for us to lay them all out. But as for the ones mentioned by Mr. Chen, is possibly likely to happen. Do we have any precedents that you can share, perhaps with regular members of the public, so that they know about the accountability issues? Assistant Director, if the issue happens within the MC, say if a person is not responsible for signing the agreement or carrying out the procurement, they give advice to another member of the MC who is responsible for the procurement. That person may, by implication, be assuming the responsibility for carrying out the procurement. If they are the member of the MC and they give advice to another person, they may, by implication, be involved. But if the member of the MC just asks for advice from just a regular person who is not a member of the MC, then that person giving the advice may not be held accountable. And that's not something that we can regulate under the laws. When we're explaining the laws to the community, we will give them some scenarios. Thank you. Mr. Lee or Mr. Lee, please proceed. If we may refer to the list of amendments, we have addressed the first item, that is the definition of persons accountable. Now we move on to clause 3 of the bill. That is the second item on the list. We will be amending section 2 bracket 1. If you refer to page 2 of the annex, we have a definition for the responsible person. Have you talked about 4B? We will come to it later on. Now I follow the order on the list of amendments. This page 4 of the annex, the definition of responsible person will be amended. Under bracket A, Roman numeral 2, we have made some textual amendments because members have questions regarding the Chinese translation of obliged, and we have amended it accordingly from Yimo to Zatyam. And members ask if the person who is responsible for making copies would become responsible person. We don't think that's the case. That is why we add this substantive matters in respect of after management in connection with, so that persons who are making copy don't have to make declarations. That's the new definition of a responsible person. Please proceed. Also under clause 3, we propose to amend section 2 bracket 3 to bracket 5. These are miscellaneous amendments to make it clearer and to align the Chinese and English versions. If you refer to page 6 of the annex, under bracket 3, this is about the adjourned meeting. To avoid doubt for any meeting that is adjourned, a reference to the conclusion of the meeting in this ordinance is a reference to the conclusion of the last adjourned meeting. Members think that the Chinese translation of the conclusion of the last adjourned meeting is not easier to understand, so we amend the wordings. For bracket 4, relating to the reference to a participant of a management committee, it refers to a secretary or treasurer of the management committee who is not its member, and we put on the Chinese version who is not its member in a bracket. Under bracket 5, a person who has a connection with another person have to make declaration. We only amend the Chinese version. That is, we have to include cousins on the father's side in the Chinese version as well. There's no difference in the English version because cousins would cover all cousins on the mother and father side, so we don't have to make amendments in the English version. On page 7 of the annex, again, the Chinese translation of the word obliged will be amended. Thank you. Please proceed. Thank you. We have discussed section 2BA, that is clause 4 of the bill. Now we move on to section 2C bracket 1 bracket A and bracket 1 and B1. Let's look at subsection 1 of 2C, that's page 8 of the annex. We talked about this last time. On defining type 1 and type 2 high value procurement, we discussed the Chinese translation of the word value. And now it's 作價, which means valuation, and the members think that we should amend it to 價值, that is value. Similar amendments are to be made under bracket B, bracket 1. Now we move on to subsection 3 of section 2C. Members think that it's not proper for us to use the words "it's available" here. We're referring to type 2 high value procurement, and this is about the average expenditure of the last 3 financial years of the management of the building. And it says here that if it's available, then we should use the average annual expenditure of the last 3 financial years. And we will be repealing that part. That is, the words "is available." The same goes for bracket 8. We repeal the words "is available." To make it clearer, we add the words "there is" after "if." To put it simply, if there is annual expenditure records available, then we will make use of the average of the last 3 financial years. Mr. Lee, please proceed. Now we move on to page 2 of the list of amendments. There's section 2C, bracket 6. It's on page 11 of the annex. A set of financial statements has. We used to use the word have, and because of the members' question, we changed it to has. That's a textual amendment. Now for clause 4 of the bill, that is section 2D, bracket 2, that is about the definition of large-scale maintenance procurement. One of the key is that the value of the supplies, goods, or services divided by the total number of flats of the building exceeds or is likely to exceed $30,000. And we will not be including a garage, car park, or carport because in some buildings they have a number of garage, car parks, and that may dilute the number of flats, and as a result, the procurement amount may not exceed the threshold and not be subject to regulation. That is why we will be excluding the part of garage, car park, or carport from the building under the definition of large-scale maintenance procurement. So what if the building makes up of just car parks, garage? Under subsection 2, we add this sentence: unless every flat in the building concerned is or is part of a garage, car park, or carport. Then the reference to flats does not include any garage, car park, or carport.
Let's move on. Thank you. Staying on clause 4. 2E to C and 5B. Chinese textual changes. Members can refer to pages 12 and 13 in the annex. we were discussing electronic provision of documents. Something has to be accessible with the naked eye, without aid. In the English text, there's no reference to the naked eye with aid. So in the Chinese text, under section 2E, 2 bracket C, and also bracket 5B1, we remove the references to aid in the Chinese text. Moving on. Amending proposed 2 bracket 6. And this has to do with the definition of electronic record. We defined electronic record in detail. We reproduced the definition from the Electronic Transactions Ordinance, but now we are making a change. We use a direct reference to the Electronic Transactions Ordinance elsewhere, so members suggested adopting the same approach here. So in information system and also electronic record, we adopt the same approach, meaning a direct reference to the meaning given by Section 2, subsection 1 of the Electronic Transactions Ordinance. That keeps things simple. If members are all good, we come to the proposed Section 4A, keeping of proxy instruments. Section 4A. When an owners' meeting is held, proxies are received, all those responsibilities fall under Section 4A. Members mentioned whether we keep only valid proxy instruments. Failure to keep those proxies attracts criminal liability, so members suggested greater clarity. That's why we adopted members' comment under Section 4A, subsection 1. Now, for meetings of owners convened under Section 3, 3A, or 4, and those proxies have been lodged, those instruments are valid. Rather, those will have to be kept regardless of whether those instruments are valid under the ordinance. We now come to Section 4B. We touched on it a moment ago. This is the statutory defense. Section 4A is about the keeping of proxy instruments. Section 4B, subsection 1. A breach of Section 4A is an offense punishable with a fine at level 4. Now we're bringing in the concept from the new Section 2BA. For an MC that breaches the provision, every person who is accountable for the breach commit an offense and is liable on conviction to a fine at level 4. Sections 3 and 4 are the statutory defense. Now, for someone charged with an offense under subsection 1 or 2, this person can establish that they have exercised all due diligence so that they do not commit that offense. That is a defense. Subsection 4 elaborates on subsection 3. So under conditions A and B, this person will be deemed to have established that they have exercised due diligence. For A, sufficient evidence to raise an issue with respect to that matter. And B, the contrary is not proved by the prosecution beyond reasonable doubt. So that's the statutory defense I was referring to. Thank you, Chairman. Professor Priscilla Leung. If this bill is passed, we want owners corporations to act in concert. Now, for individual members that are punished, this is a fine at level 4. That's for minor criminal offenses. Money is involved. We don't want to broaden liability, so we narrow the scope. Not the entire OC is punished. Still, there should be an advice, some kind of suggestion to the OC. The OC and the court may see all due diligence differently. The OC thinks they have done their best. So can the OC help pay that fine? This is a practical question. This is a suggestion. We need clarity. So can the OC pay the person who had to pay that fine in the first place? Mr. Alfred Lee, we note Professor Leung's comment. This is a sensitive matter. We can revisit this matter after the meeting. Our experience shows normally OCs act as a group, otherwise you cannot hold a meeting. When disputes arise, certain MC members are not doing their job, and then there is resentment among owners in that building. Someone files a complaint, prosecution results, then the statutory defense kicks in after a court hearing, and then someone is found to have breached the law and has to be held criminally liable. Some property owners may feel that the defendant has got their just desserts. And then at that point, if we require owners to chip in to help pay the fine, someone may feel aggrieved. So we have to tread carefully. Now, someone may voluntarily try to help this person who was just fined, but that falls beyond the scope of Cap 344. People may offer help on a personal basis. That's beyond the exercise here. Within our current context, if we make it a requirement for the OC to chip in for the fine, some people may feel that's unjust. And then we may also encourage the thinking that it's fine to breach the law because someone else will help them out. So we have to strike a balance. Undersecretary. Mr. Alfred Lee was explaining the bill. For me, I note Professor Leung's concern, which is a matter beyond this bill. I know Professor Leung has been following matters about OC's work because she has been involved in her district work involving OCs. So I can see where Professor Leung is coming from. After this bill is passed, we will step up public education. There will be guidelines. We will also provide greater support. Some OCs may not have the help of professional property management companies. So in that case, we provide support. There will also be public education. There will be consulting services. Now we can get property management firms and NGOs involved to help existing OCs. For us, we want OC members to get along with one another. This ordinance is there as a guide when disputes arise. Prosecution is the last thing we want to see. People serve on an OC on a voluntary basis. We want them to be clear on the roles and responsibilities. Mr. Lai Tong Kwok. Can the government explain to us the differences between the new Section 4B and the old Section 4B? A cursory glance shows the drafting has changed such that it's easier to follow when you read the new Section 4B, but the changes are more than that. Under the new subsection 4, something is removed. Why remove something under the old subsection 4? Mr. Alfred Lee, indeed, we scrapped the old paragraph 4. We do that because the old drafting, the defendant is entitled to something. That phrasing is awkward. The old drafting suggests some sort of entitlement on the part of the defendant. So we scrapped the old paragraph 4. So under the new subsection 4, someone who has exercised all due diligence can raise this defense. And then under subsection 4, we elaborate on what it means by exercising all due diligence. So 1, raising an issue with enough evidence, and then the contrary cannot be proved by the prosecution beyond reasonable doubt. When you read subsections 1 to 4, you can see how a person can raise that defense and will not be prosecuted. Mr. Lai. The old subsection 4A1 says the offense was committed without the person's consent or connivance. Now, the new subsection 4 has dropped that provision. So can the government explain the thinking behind dropping that provision?
Mr. Lee, please. That is correct. Under the original subsection 4A1, there is this element of consent or connivance. Originally, the entire MC would be held accountable, so more than one person would be involved. That is why we provide for such a scenario where someone would only be accountable if they have given consent or connivance. As we have narrowed down the scope of accountable person, and under Section 2BA, we have defined who will be held accountable for any contravention. That is why we don't have to establish a defense for individuals. That is why we repeal subsection 4A1. Regarding the documents submitted by the administration yesterday, we have had discussions. So would legal advisors please give us some comment? Thank you. I would like to ask the administration to clarify Section 4B. It is proposed that if a committee or management committee contravenes the ordinance, every person would be held accountable. And as explained by administration, the prosecution will be tasked to prove if someone should be held accountable. And under 2BA of Section 4B, a person who assumes responsibility under the management company would be held accountable, whether expressly or by implication. So this concept of assuming responsibility, does it mean that the person knowingly carries out the duty such that this will no longer be a strict liability offense? Because the administration explained earlier that they want this offense to be a strict liability offense so that no mens rea would need to be proved. So by adding this element of accountable person, would that make the offense not a strict liability one? Mr. Lee? Thank you. This is still a strict liability offense. When a person assumes responsibility, they would know that they are carrying out such an act that contravenes the law. So we don't have to include this words knowingly here. We want to narrow down the scope of accountability while keeping the offense as a strict liability one so that we don't have to prove the mens rea. Still, we have to look at the circumstances, if the person is actually carrying out the duties, and we will see if the person can raise a defense. Professor Priscilla Lang. I would like to add that the comment that I gave was about a good person and a bad person. If the member is with good intent and they inadvertently contravenes the laws, the entire management company should help that person who were subject to fine. We want to penalize someone who have broken the law on purpose. We shouldn't just hold a person liable because otherwise no one would be willing to take up any responsibility in the management company or a committee. We want the entire MC to work collectively. No need for a comment, reply. I understand what Professor Leung is talking about, but as we've mentioned, we have made this definition of accountable person very clear, and we will be providing for a defense. For a person to be held criminally liable, a series of procedure, adduction of evidence will have to be gone through. Of course, the entire MC should work together to better manage a building, and we all support this. Undersecretary Mr. Leung, do you have anything to add? Thank you. Chairman have said what I wanted to. Professor Leung is very right. We want to distinguish the bad guys from the good guys. After amendment, good members can rest assured. And people can continue to join the MC to contribute. Mr. Lai Tongkwok. I agree with what the legal advisor said. If a person, as a participant of the MC, assumes responsibility, then that's their decision. That's not just an action. The person would have to have the intention to do so, and that may constitute criminal intent. The prosecution would have to prove beyond reasonable doubt that the person has committed an offense, and they have to establish that a participant of MC assumes responsibility for taking the action. I don't think that this is an issue. The burden of proof falls on the prosecution. MC members work on a voluntary basis. When we enhance the burden of proof on the part of prosecution, then the members of MC would not be as worried. Thank you. We want to strike a balance. We need to ask the bad guys to be held criminally liable. This is what Mr. Lai said. In terms of a burden of proof, we have to be very clear about that. Next, Mr. Paul Chen. I want to ask the administration to clarify this concept of expressly or by implication. By expressly, that's very clear. That means someone has been appointed to carry out the action. But what about by implication? What scenarios would constitute by implication or assuming responsibility by implication? Mr. Lee? These concepts of expressly and by implication are widely used under common law system. For expressly, it's clear. Someone has been appointed verbally or writtenly or in written form to carry out some duties. By implication, we mean that someone has been carrying out an action regularly, then that person will be carrying out the duty by implication. And if someone, for example, is keeping the key to the cabinet that keeps the documents, then that person will be assuming the responsibility of keeping records by implication. There are some objective truths that show us if someone is assuming responsibility by implication. Thank you. Mr. Chair, any follow-up question? No. As I said, the administration submitted this LC papers number CB bracket 2 733/2024 bracket 01, and we have discussed it just now. If there's no other questions, then we will conclude our discussion on this set of paper. But then Undersecretary and the Assistant Director would still need to submit the response to the points raised by members in previous meetings. And also on the 27th of May, we have raised some concerns, and we need the administration to respond to that. Undersecretary, do you have anything to add? Thank you, Chairman. Once again, I would like to thank the Bills Committee. As I mentioned, our colleagues are working on the remaining draft CSAs. We target to submit the relevant documents to members tomorrow. As for the proposed CSAs mentioned on the 27th of May and the rest of the replies, they will be submitted to LegCo by this Friday. I hope that will facilitate our meeting on the 3rd of May, and on the 3rd of June, we will make everything ready. Dr. Lo Wai-kwok. Thank you. I think that we are about to come to a close. I would like to raise some issues here. There are some people online who have questions regarding the keeping of records because failure to keep such records would attract criminal liability. And there were people online who said that they are aware of the scrutiny of the bill and they don't really understand the content of the bill. And they are worried. I hope that this bill will be passed as soon as possible, but in terms of promotion and publicity, well, I think that we have to help 3 new buildings without owners corporate and existing owners corporate understand the bill and know what to do, and we need to encourage them to better the building management. I want to stress this point, and this is suggested by a lot of people online. Undersecretary, thank you. We hear Dr. Lo's view and concern. Actually, all BC members ask us to step up publicity after passage of the bill. And inside and outside the chamber, I have been talking to the members about this bill. The 18 Home Affairs Department offices have support for the Owners Corporation, and the Home Affairs Department have been talking to different owners corporates, and we organize seminars regularly. And we have engaged professional management companies to these seminars to answer questions raised by owners corporations. And we also offer free of charge legal advisory services. We will only step up such services in the future. For any inquiries concerning a single building and 3 new buildings, we have an enhanced BM pass. We will update our guidelines in the future, so I'm confident in our work. But then, of course, if members receive any inquiries regarding building management, please refer them to us, our colleagues of Home Affairs Department, and we will address them. Thank you. Agenda item number 2, any other business? We have sent a set of documents to members on the deadline for giving notice to move amendments. That's 12 noon on the 31st of May 2024. If you have any proposed amendments, please send the draft to the Secretariat before that. The next meeting will be held on the 3rd of June 2024, Monday, 4:30 to 6:30 p.m. Please attend the meeting on time. The meeting is adjourned. Thank you.